introduction here. So I just want to welcome everyone to New York Law School. I'm Anthony Crowell, the Dean and President, and it is a tremendous honor to be with you today as we host one of the nation's most preeminent constitutional law scholars, Laurence Tribe. We are also fortunate today to have Jeffrey Toobin with us, who will interview Professor Tribe, and we are honored to host so many distinguished guests, including from our state and federal judiciaries. The Shainwald Lecture has always been a wonderful event, and each one has featured momentous national leaders, including 3 Supreme Court justices, Sandra Day O'Connor, Stephen Breyer, and Ruth Bader Ginsburg, who was our most recent Shainwald Lecturer, and others have included U.S. House Speaker Nancy Pelosi and former senators and cabinet secretaries John Kerry and Chuck Hagel, and the late Senator Ted Kennedy and former Senate Majority Leader George Mitchell. The lecture was founded by Sybil Shainwald. Yes, Sybil. Sybil is a powerhouse and one of our most distinguished alumni, and she is a trustee emeritus. And it was founded in honor of her late husband, Sidney, who led an incredibly dynamic life as a highly successful accountant and consumer advocate. Sybil is a 1976 graduate of the law school, and she attended here as an evening student after a very successful career as a consumer advocate. She's been in practice now more than 40 years. And armed with her degree, she became, as you all know, one of the foremost legal pioneers in the world, a visionary who's made fighting for women's health her unrelenting mission for the last 4 decades. Her impact and her legacy can be seen and felt everywhere, from New York to Bangladesh. And we're so grateful that she has invited Professor Tribe to our campus today. He's the Carl M. Loeb University Professor and Professor of Constitutional Law at Harvard, teaching there for 51 years. Anyone who has studied law in the last 5 decades considers Professor Tribe to be the most influential constitutional scholar of our time. And that may be best represented through his seminal treatise, American Constitutional Law, which has been cited more than any other legal text since 1950. His influence extends far beyond our border, helping to write the constitutions of South Africa, the Czech Republic, and the Marshall Islands. And for me, as a law school dean, one of Professor Tribe's roles I most admire is when he served as our country's first ever senior counselor for access to justice, appointed by President Obama. That service inspired so much of the progress we've seen in establishing access to justice, and it serves as a constant reminder for those of us in American legal education of our responsibilities, both in good times and in bad. He is a prolific scholar and an indispensable guide for everyone in better understanding the most critical and constitutional issues at stake for our nation. And of course, that's never been truer than today, with the current impeachment process taking place in the House of Representatives. This is a deeply profound and historic moment for our country. And with the House passing a resolution setting forth the formal procedures for impeachment, Professor Tribe's perspectives will be essential for all of us, including lawyers, members of Congress, and all Americans, to understand the law and issues being brought to light. Our entire community is incredibly grateful to have him here today, and we are honored. I know everyone in the room is eager to hear from him. It's now my pleasure to ask Sybil to offer a few words and to introduce another significant member of the New York Law School community, Ken Feinberg, who will give more formal introduction of Professor Tribe. Sybil?
Move over.
I'm gonna move over.
Thank you all for coming. Thank you. Thank you all for coming. My husband, in whose honor I do this every, well, almost every year. Right? And you, all right. No. If you look at the screen, you will see the former lecturers, and everybody has been really distinguished, and we have two distinguished, well, we have two exceptional people here today, Professor Larry Tribe and Jeff Toobin, who's everybody's heard on CNN. I just want to welcome everybody and not take too much time, but I did want to say a few words. In the program book, I have taken quotes out from this book, which I have read and urge you to buy. I don't usually mark up anybody's books like this, but it's an unusual book. It will really explain the current situation we're in, and you know, I want to say just a few more words about my husband, who was exceptional, witty, wise, and supportive of his wife, as Mr. Feinberg can attest to. Put up with a lot. But I just want to really say that Sidney Shainwald tested suntan. He started out because he was as a consumer advocate. So while he was at City College, he tested suntan lotion on the roof of Consumer Reports offices in the magazine's early years. He wrote a thesis on comparative product testing. Later, when he had a family, he brought home mouthwash and lotions and many other things for them to rate. So we were the guinea pigs. So perhaps it is not surprising he sometimes thought about people the same way. In a tribute to Colson Warren, the founding president of Consumers Union, Sidney wrote, "If Consumer Reports were to make a product evaluation of Colson Warren, it might read something like this: a unique bottle, a once-in-a-lifetime production, exceedingly efficient, definitely top-rated, and the best buy ever." So, during Sidney's tenure at Consumers Union, the organization established consumer advocacy offices in Washington, San Francisco, Austin, and it became involved with the environmental movement and won a National Magazine Award for a series on contaminated water systems. Also under his tenure, Penny Power, a magazine for children, was launched. It is now known as Zillions. At the time of his retirement, I told you about the beginning, but at the time of his retirement, there were 110 consumer organizations in 46 countries. Today, there are more than 220 consumer organizations in 110 countries, according to the International Organization of Consumers Unions. Even after his retirement, he had a consumerist bug. For example, the Red Cross was supplying contaminated blood. And his testimony was that the Red Cross had enough money. He wrote in a report commissioned by Money Magazine in 1986. "If it were public, I'd love to own stock in the Red Cross," he said. At any rate, as far as I'm concerned, Sidney Shainwald is the best buy ever. Now I want to call on Kenneth Feinberg, whose bio I have left at home, but I think everybody knows Mr. Feinberg because he's the master of the universe. So he will introduce the next speaker. He is, you all have read about him, I know, and I'm very pleased to have him here. He was the first lecturer, by the way.
Thank you all very, very much for being here. When the dean mentioned this lecture series, and he went down the list of lecturers, justices and senators, but he didn't mention the first lecturer in this series, the very first lecturer. But that's all right. Sybil managed at the end to sneak that in, and that's terrific. I have the distinct honor now to introduce our guests, our guest lecturer and our guest interviewer. I must tell you a story about how important this lecture series has become nationwide. I got a call from Professor Tribe, and this was a few months ago, and Professor Tribe said, Ken, I'm really inclined to do this. Are these names of past lecturers legitimate? I mean, is this real? Am I following in the wake of these people? Did they all actually? I go, yeah, it's not a forgery. They have been the lecturers. He goes, I'm doing this for sure, if that's the case. And we're very, very honored and pleased that he's here. I also want to acknowledge what I think the dean said. This lecture series has become a nationwide, credible, important lecture series, covered all over the country, really, over the past 11 years. And there are two reasons for that, aside from, of course, the institutional support of this distinguished law school. First, absolutely, we owe a debt of gratitude to Sybil Shainwald. Sybil, starting tomorrow, will start asking people, what should we, for the 12th, should we get this person? What about this person? What about this person? Hands-on Sybil Shainwald. And the second reason for the success of the program is the legacy of Sidney Shainwald. If you knew Sidney, as I knew Sidney, you can understand why this lecture series really is a memorial and a remembrance of Sidney, and for the role that Sybil and Sidney have played in making this lecture series so successful and so dominant. That's why we're here today. Okay, I introduce first Professor Tribe. As the dean pointed out, Larry Tribe is the foremost constitutional scholar in the United States. He is in constant demand on the academic side, but far from Larry Tribe to be an academic. He is also waging every day in the lists, waging war, and a very practical and very prominent public policy figure. And we are indeed very, very fortunate to have Professor Tribe here. I can tell you, for the last 40 years, I remember 40 years ago, when working for Senator Ted Kennedy, a week would not go by in Washington where Kennedy wouldn't say to me or to then Chief Counsel Stephen Breyer, what does Tribe think? What does Tribe think? What does Tribe think? And we would reach out to Larry Tribe informally, constantly offering his advice at our request in a number of important public policy issues. Jeff Toobin is, by all accounts, the foremost legal analyst in media, print, TV, radio, than any other person in the United States. And I think the main reason that Toobin is such a success as a legal analyst is he happens to be a lawyer. It helps. It helps to be a lawyer. And he's had a distinguished legal career as well as a distinguished career in the media. The idea that we have at the same time today Larry Tribe and Jeff Toobin just goes to show, Sybil, that you are continuing your perfect record in gathering together the very best for this distinguished lecture series. I give you Professor Tribe and Jeff Toobin.
Hello, everyone. Is this working? I don't think so. Is it? Is it? Hello? Is it working? Okay. Hi, Larry.
Hi, Jeff. Is this working?
Okay,
Hi,
here
everybody.
we go. All right, so this is what we're going to do. We're going to talk for a while about Larry's life and experiences, and then we're going to get into impeachment and all the sort of news of the day. And the first question I'm going to ask is, you were born in Shanghai. How did that happen?
Well, my parents were there.
Yeah.
No, they were Russian Jews who emigrated across Russia. My mom actually was born in Harbin, Manchuria. My dad was born in Belarus, and their parents were born in, actually their grandparents were born in Ukraine. So they were part of the Jewish diaspora. And I was lucky enough to be born in Shanghai, where they were welcomed. Not many places in the world would welcome Jews at that time. And I was born just a little bit before Pearl Harbor. My dad had, in the meantime, in his 20s, come to California, become an American citizen, which, as it turned out, wasn't the best thing to be when the Japanese occupied Shanghai, because enemy nationals, American citizens and British citizens, were interned in Japanese concentration camps. So I grew up with my mom, because she was a stateless person and I had no citizenship, with my dad in prison. And the rest is what happened. I mean, I survived. My dad was released.
So wait a second, your dad was in prison in Shanghai?
Yeah.
And you were there for 5 years?
Yes, until I was 5.5.
And the three of you got out?
The three of us, actually the four of us. My late younger brother was almost a year old when we went in actually a troop ship, because we had no money, but we were in the hold of a troop ship called the SS General Gordon, which went across the Pacific, which was then a long voyage to San Francisco, which is where I grew up, went to public schools until I was about 16, and then came to Harvard and have been there ever since. I mean, I obviously not very peripatetic because I was stuck there. It's not a bad place to be, not a bad gig for 51 years, and that's where I've been for a long time.
And as an undergraduate, you were a math major.
Yeah.
Now, what's up with that?
What's up with that? What's up? So I love math. I still love it. It's the most beautiful thing I know. I mean, I'm kind of a Platonist. I believe there are absolute truths. I mean, I still remember scrawling on a bathroom wall in Lamont Library, e to the I pi plus 1 equals 0. Therefore, God exists.
It's funny. I did that too. I have no idea what that even means. So.
Well, it's Euler's equality, and it sort of means even deeper things than the cosmological truths. I mean, in every possible universe, that's true. And I just love that. And when I went from math to law, because I thought I wasn't going to be a great mathematician. I was pretty good, but I wasn't going to be great. And I wasn't going to make any difference, but in law, maybe I would. And when I made the shift, first thing I noticed was how much more difficult law was. I mean, you really couldn't ever put QED at the end of a legal argument. There were these human variables, and at first that kind of frustrated me, but then that became what I really loved.
Okay, before we get to law school, you are the second most famous math undergraduate at Harvard of the mid-'60s.
And the most famous was in Eliot House with me at the time.
Ted Kaczynski.
Ted Kaczynski, yes.
Tell us a little about Ted Kaczynski.
Well, I don't remember much about him. I remember he was a loner.
What a
time, and we're in the same house. Would you be a character witness for Ted? And I said, well, I don't remember him that well. No, and I declined. I declined to be a character witness.
But so you go to law school, and the indeterminacy of it appeals to you?
Yeah, I mean, it was a combination. I had a roommate in graduate school when I was finishing my work in math, and he was in law school, and he thought it would be fun to show me one of these classes. So I went to a class. It was in admiralty law, and I remember the teacher was deeply steeped in history. It was Mark de Wolf Howe, and admiralty law, I thought, had to be really romantic. I had just finished reading Moby Dick, and I thought, you know, the romance of the sea, and I must go down to the sea again. And there was a certain amount of romance, and that appealed to me. It was also somewhat surreal, because I remember the hypothetical that he gave was that of a sailor who dropped some... Oh, Nadine, hi. I've just noticed Nadine Strawson is here. And there's so many people I know, but I just happened to notice her.
Mine too.
Yeah, and also Kathleen Sullivan's, and also Joel Perwin's, and also John Barrett's, and also Adam Samaha's, and also Barack Obama's, and also Adam Schiff's, and also... No, I've been so damn lucky in having such amazing students. Where was I? I was talking about the dropping of the anvil on the foot, and it broke his foot. And he used that, apparently, to prove that the vessel was unseaworthy because he had dropped the anvil on his damn foot. And Mark de Wolf Howe explained how the concept of seaworthiness... Oh, and also my classmate, Liz Holtzman, is right here, who knows more about impeachment than anybody, except maybe I know as much, but not more. But anyway, the very idea that you could prove that the ship was unseaworthy because you were stupid enough to drop something on your foot struck me as paradoxical, surreal, and I thought something that is romantic but that supposedly uses reason and that relies on history and that has these surreal paradoxes, that's for me. I really loved the idea of working out puzzles in which the variables were not straightforward and in which human consciousness, human foibles, human culture played a role, and I fell in love with the law. And it turned out to be something that really was both beautiful, though not as beautiful as mathematics. Nothing quite makes it as beautiful as mathematics. Beautiful, but also practical. You could actually help people. I remember, you know, representing with Kathleen, representing people who wanted to reform the land laws of Hawaii, working, you know, with John Barrett on issues about this independent counsel law, working with Joel on a lot of things. I mean, you could actually help people. Migrant workers, gay people, lesbians, trans people. You could make a difference. You could work, you know. I could go on.
Yeah, and you will, as you should. After you graduated from law school, you clerked for a great justice of the California Supreme Court,
Right.
Matthew Briner,
Right.
and then for Potter Stewart on the Supreme Court.
Right.
So you have, and that was the 1964 term?
No,
was it?
67.
67.
8.
And, you know, you have seen the Supreme Court in a, you know, as an advocate for many years, but you were also sort of on the inside, at sort of towards the
Right.
end of the Warren Court. What was it like at the Supreme Court in the mid
Yeah.
60s?
Well, it was wonderful. First of all, there was no predictable partisan polarization. There were Republicans like the one I clerked for, Potter Stewart, who were liberals in some ways and conservatives in others. There were Wall Street lawyers like John Marshall Harlan, one of the most distinguished graduates of the New York Law School. He was going blind at that time, and the greatest lawyer of the 20th century was helping him, Thurgood Marshall. We had, you know, in those days when Potter Stewart said, I can't define obscenity, but I know it when I see it, we used to actually look at it. That is, we would go to the basement of the Supreme Court to see these porno flicks, to see, you know, whether they did or didn't make it by the Stewart standard. And Harlan, who was blind, would turn to Thurgood and say, Thurgood, so what did he just do? And Thurgood would say, and then John Harlan, a very proper gentleman, would say, that's impossible. So that's what it was like. And there were interesting cases like the draft card burning case, the stop and frisk case. I had the great privilege of drafting some really important opinions, Katz v. U.S. and
Katz v. U.S.
Yeah, right.
We all studied in criminal
Yeah,
law.
yeah.
Tell what about
Well,
Katz.
that's
a great case.
It's a great case. This guy goes into a phone booth. You know what those were? There were
Yeah.
phone booths, and he's placing bets, gambling bets, and the FBI kind of knew that that's what he would be doing, and they put a wiretap on the phone booth, and then that evidence was introduced against him. And because they hadn't trespassed a place that was his property, the law at the time said that there was no Fourth Amendment occasion. There was not even a search and seizure, therefore you don't need a warrant. And the case reaches the U.S. Supreme Court. Marshall, who had been Solicitor General, recused himself. It was an 8-person court. The court was split 4-4. And I was clerking for Stewart, and I said, well, don't you think that Olmstead, the decision that had said you don't have any Fourth Amendment right unless there's an invasion of your physical space, don't you think it should be overruled? He said, Larry, you're new here. You don't realize we don't just overrule things every day. And I was persistent, and he said, look, the Dragon Lady has said that this is coming down Monday. The Dragon Lady was Mrs. McHugh, who was the administrator of the court for Earl Warren. And when she said something was going to happen, it was going to happen. And I almost got myself fired because I just insisted that Justice Stewart give me a chance over the weekend to draft something that could command a court. And he said, it's impossible. Douglas is on one side, Fortas is on another, you'll never do it. He almost fired me. He said, you're new here, you don't know what's going on. But anyway, long story short, I wrote a draft. It became the opinion of 7 justices in Katz, and it held, overruling Olmstead, that the Fourth Amendment protects people, not places. There's been debate for decades. What does it mean? What are the expectations of privacy that are reasonable or justifiable? I had some notion that you could combine the First Amendment with the Fourth, because what's justifiable is a normative question, and if, in fact, we have to think that Big Brother might be listening to every conversation, then we will not have a system of free and open communication. That was one of the cases that I really, to this day, am very proud to have had a chance to work on. There were others, but that was one of the best.
So after clerking, you go to Harvard and you're teaching, and then you decide to write what we used to call ACL, your treatise, American Constitutional Law, which is really about all of constitutional law. I mean, it is an incredibly ambitious undertaking. And when I went to look at my copy the other day, one of the things you say in the introduction to the first edition is that Sergeant Shriver had an important role in your decision to do that.
Right.
Now, I assume in a distinguished group like this, most people know who Sergeant Shriver was. He was the first head of the Peace Corps. He was married into the Kennedy family, George McGovern's running mate in 1972, not very successfully, but
Right.
How did Sergeant Shriver come to get you to write ACL?
Well, I got to know a friend of Ken Feinberg's, Ted Kennedy, and Ted introduced me to Sarge, and Sarge to Eunice, and the two of them to their amazing 5 children. And I got to know them really well, and I was being considered for Solicitor General in, I guess it was the Carter administration. I had no qualifications for the job. I had never argued a case. It was kind of crazy. But I got myself into thinking, maybe I'll be SG. And it seemed like a cool thing. And when it didn't happen, I was really dismayed and disappointed. And Sarge said, never mind. You realize you're working on this book. You told me you're trying to write up something about the whole Constitution. I said, yeah, but that's just impossible. I'll never get it done. He said, look, how many former Solicitors General do you know? What difference have they made? A couple of them, maybe. But if you finish this book, Larry, it's going to make a huge difference. And somehow I loved and respected the guy enough, given what he had done in the Peace Corps and given what a wonderful human being he was, that I actually took that as my charge to actually do it. And I holed up in the basement of Langdale Hall, big boiler room operation. I'm still very klutzy, and so I couldn't change. You know, in those days, we didn't have word processors, let alone computers. We had, however, Selectric typewriters, the IBM Selectric, and I couldn't change the tape myself because it was just all so messy. So the school rented for me 11 typewriters, 11 IBM Selectric typewriters, and they were in a row. And when I did a lot of this as a first draft, and when I would finish part of some section of some chapter, I would move on, and the tape would run out. I'd move on to the next typewriter. And I did this without taking a leave while teaching. It was really crazy. I don't know how the hell I did it. But 9 months straight of writing, and, you know, finished.
And there it is.
And there it is.
And how did you come to start arguing cases?
Well, I went to some kind. I think I had given a bar review lecture, and some guy in the audience said, "You know, I'm representing the Richmond newspapers, and they were prevented from attending a criminal trial, and the only reason they were excluded is that this judge said that the room wasn't properly designed for public observation, but in fact, his reason was that it was kind of a done deal. He wanted to acquit the guy who was accused of murdering this woman, and the prosecution didn't want the public to see this deal worked out, and the accused didn't want the public, and the judge didn't want the public, but the public wanted the public. And I was kind of sympathetic, but I said, I can't really see how I can make much of a First Amendment argument, because the First Amendment isn't a Freedom of Information Act. It doesn't give you a right to see stuff that people want to keep secret. And there's no willing speaker here. But listeners should have a right, and maybe the Ninth Amendment has something to do with this. And he said, you know, I like the way you think. So anyway, the Richmond newspapers, it was pro bono, asked me to do this argument. I had a real tough time convincing the kind of pillars of the free speech bar, like Floyd Abrams and others, that it was worth mentioning the Ninth Amendment. He said, Larry, you're crazy. This is just a free speech case. I said, I don't know that I can quite do it on free speech grounds. So I made an argument saying this isn't quite covered by the free speech clause, but the Ninth Amendment says that the fact that something isn't quite covered by the Bill of Rights doesn't mean it doesn't exist. And there's an underlying presupposition that the press and the public and the victims have a right to see justice done, whether or not the parties want to. And sure enough, Berger, who wrote the plurality opinion, relied on the Ninth Amendment along with the First. He said the Ninth Amendment was added by James Madison to prevent the Bill of Rights from being like an exclusive bill of lading, and it became an important Ninth Amendment precedent. So that case, but I had never before argued anything. I didn't, by the way, tell him. He didn't ask, have you ever argued a case in the Supreme Court before? If I had told him, maybe I wouldn't have been asked to do it. But after that happened, people started asking me to argue cases, and so then I argued several dozen.
And you argued a case when I was just out of...
By the way, you guys are not here to learn about me. You want to learn about impeachment, right?
No. We're almost there.
Okay.
Don't worry. I'm in total control here.
Okay.
Bowers v. Hardwick was
Yeah.
1986, the year I graduated from law school. Tell folks about Bowers v. Hardwick.
Yeah, no, that was a very, very important case in my career. I've always been sympathetic to LGBTQ rights. Michael Hardwick was a guy who he'd picked up somebody at a bar and gone home, and they had oral sex, I think. The cops followed him home, arrested him for violating Georgia's sodomy law, and the case gets to the 11th Circuit. I had nothing to do with it at this point, and the 11th Circuit says that when consenting adults have sex in private, the state needs an extraordinary justification for criminalizing what they're doing. The guy wasn't in jail except overnight, but the issue of whether the state had to give an extraordinary justification for going after gays or straights who had merely had consensual sex in private was up for grabs. And I didn't think the court was ready really to rule in his favor, but unfortunately the court granted cert. And I was asked to argue the case. Kathleen Sullivan worked on it with me. And I argued on behalf of Michael Hardwick against Georgia Attorney General Bowers that the issue wasn't what Michael was doing in his bedroom. In fact, the complaint that he filed, the civil rights complaint, didn't detail even the gender of the person he was with. The issue wasn't what Michael Hardwick was doing in his bedroom, it was what the state of Georgia was doing in Michael Hardwick's bedroom. And I knew that the odds of our actually winning were zilch, because I had argued another gay rights case before the court that didn't really go down in history one way or the other. But I knew that the most we could do is get 4 votes, the 4 liberals, that we would not win. But I was hoping to get some powerful dissents. And sure enough, people like Blackmun and Stevens wrote some great dissents. And for years I told my students, when they read the opinion in Bowers v. Hardwick, this case will be overruled before too long.
And just before we get
Yeah.
to that, Lewis Powell, who was the 5th vote against you, was asked in retirement,
Yeah.
was there any vote he regretted? And he said Bowers.
Well, regretted is a little strong, because he didn't really regret it. He says, was there anything you did that you think you made a mistake about? And he said, yes, Bowers. I should, but the mistake didn't matter, he thought. He said, because he said, and it was at not New York Law School, but NYU that he announced that he thought he had voted wrong. He said, because after all, these laws are not really enforced. Michael Hardwick didn't spend any years in jail. What he didn't understand was that these laws are used to harass gays, that they're used to deny gays the right to adopt, the right to marry. So when he said he thought he was wrong, I wrote him a letter saying, better late than never. I'm really glad that you say you were wrong. And he wrote a letter back, which I unfortunately can't find. And therefore, I'm not able to donate it with my papers to the Harvard Law School Library. But the letter back basically said, yes, I was wrong, but it didn't really matter. Little did he know how much it mattered. And what it actually did, rather than only creating an excuse for harassing gays, was help to energize the gay community. It basically became the symbol against which LGBTQ fighters and the ACLU fought. And when I ended up writing the main brief for the ACLU in Laurence v. Texas, which eventually, 17 years after Hardwick really overruled it, it was really a great and triumphant experience, because finally they overruled Powers.
And you know, not they often overrule cases without saying so. In Laurence v. Texas, Justice Kennedy very explicitly said Bowers v. Hardwick was overturned. I mean, that just must have. I mean, I found it an enormously.
Well, not
moving
only that, he
experience.
said, and this is really rare, he said it was wrong from the day it was decided. It's not just like one of those cases where the court says, now we know better, then it was right, but now we have grown. It's sort of like what they did in Brown v. Board. They didn't really say Plessy v. Ferguson was wrong the day it was decided, but here they said, from the very day we decided this case, we were insulting the dignity of all gay and lesbian Americans, and that was wrong, and it was inconsistent with the core premises of the Constitution. So that was a great moment.
Now, you have demonstrated an enormous prescience about issues that are going to be, in the public eye, and obviously we're going to get to impeachment very shortly. But again, when I was in law school in 1986, you wrote a book for a popular audience called God Save This Honorable Court about Supreme Court confirmation hearings.
Right.
What made you write that book then?
Well, the court was getting really old. I mean, the average age was like way up in the late 70s, early 80s. I mean, they seemed impossibly ancient. I'm now 78, and I can't imagine what I must have thought back in 1986 about that court. I thought it's amazing they're still alive in their late 70s. But in any case, I thought there's going to be massive turnover in the court very soon. Powell is not going to stay that long. I mean, it was sort of like there were a lot of people like, there's nobody quite like the notorious RBG, and it's hard to imagine following her at this podium and feeling grateful for it. But the fact is that there were a lot of people who were aging out like she is, and it was clear there was going to be a lot of turnover. And there was a myth going on that presidents just never can get it right, that they always make mistakes, that they pick people who turn out to be more liberal or more conservative than they believe, and that the choice of justices doesn't really shape history. And I really believed that that was wrong. I sort of studied it, and I found that by and large, when presidents want to move the court in a given direction, they succeed. I mean, the fact that Earl Warren and Bill Brennan turned out to be disappointments for Eisenhower is sort of a myth. Eisenhower picked Warren to get him out of the way in California politics, and he picked Brennan because he needed a New Jersey Catholic. And I was convinced that we were entering an era when presidents would be much more cautious and informed about picking justices who would tilt the court in the direction they wanted. And I imagined that that's what Reagan would do. And the book came out shortly before Powell left the court. So I ended up testifying against Robert Bork, saying that his vision of America was not a vision that the American people would regard as consistent with the Constitution. He thought the Ninth Amendment, which was one I really have always been infatuated with, was just an ink blot because it didn't tell you very much. He thought that racially restrictive covenants could be enforced because they didn't involve explicit race discrimination by the government. And so I testified against him, and he was his own worst enemy when he basically testified in a way that made him seem scary. And then when Kennedy was nominated, I studied their jurisprudence, and I thought Kennedy is the one who was going to cast the decisive vote to overrule Bowers v. Hardwick. I was convinced of that, and as it happens, it turned out to be true. And I testified for Kennedy.
But by testifying against Bork, though, you really put a target on your own back. I mean,
Right.
it's no secret that many people thought you might be nominated to the Supreme Court. But after '87, did you realize that you were jeopardizing your
Yeah.
own potential future by testifying against Bork?
Yeah, I had no doubt of it. I mean, I knew that I would be radioactive. I mean, I knew that these people don't forget. They have long memories. And they made it clear to me, people like Lloyd Cutler, scion of the liberal establishment, testified for Bork. And I was told, you don't have to testify at all. But if you do, you're never going to be on the court. And I thought, for one thing, who knows who's going to get to the court anyway? And for another thing, and this was my daughter, Kerry, who basically, I think, gets credit for this. She said, "Dad, do you really think he's dangerous to the country?" And I said, "Yeah." And she was a teenager. "Well, then you have to testify against him. Explain why you think that." You won't be able to. I'll tell her that she got a round of applause. And so I kind of knew that I was taking my future into my hands, and not exactly flushing it away, because I've had a great life. I mean, right now, Ken and my mutual friend Steve Breyer. I would rather not be Steve Breyer right now.
I would.
Well, look, I'm not saying I have more
People
influence.
stand up when you walk in the room. It's great.
Yeah, and you'd get to wear a black robe.
yeah.
No, but Steve, what a life it would be to have to dissent all the time, to have to deal with Gorsuch and Kavanaugh and Thomas and Alito. I mean, my God. There are people like Roberts who are decent human beings on that court, even though they're not my cup of tea ideologically. And there's wonderful Elena Kagan and Ruth Ginsburg and all. But on any really explosive issue about abortion, about racial equality, about all the rest, poor Steve is going to be dissenting all the time. And I'm going to still be teaching students who in the future will make a difference. I mean, I've had a great opportunity to teach these people.
Okay, so let's get to prescience again and your decision to write a book about impeachment very shortly after Trump's elected.
Well, they didn't take much prescience to know that a guy who was going to be violating the emoluments clauses from the first day, that is, he was going to be taking money from Russia and other countries, that a guy who had asked Russia for help being elected and then took advantage of it, didn't take much prescience to know that his very character would make it impossible for him not to keep violating every imaginable norm and abusing power and betraying the country. So I, from the very beginning, thought impeachment should be taken seriously. But I wasn't as prescient as Liz Holtzman. I mean, she wrote a book favoring his impeachment very early. My book was much more measured. I was kind of cowardly.
Okay,
I
but
mean,
let-
I said, and I still think, impeachment is such a serious, grave thing that even though in my sort of private, personal capacity, when I'd go on CNN or MSNBC or write an op-ed, I could talk about his impeachable offenses. The fact is, as a country, we have to proceed with such caution on impeachment that although I wrote in that book with another of my students, Joshua Matz, even though I wrote in that book that it's possible that Trump could commit offenses that were high crimes and misdemeanors for which he should be removed. The time wasn't ready yet for sure. We had to know that impeachment was going to be really divisive and that it was worth it, because the objective is to safeguard and save democracy, not just to get rid of a particular bad actor. But
Okay.
that time came. I mean, it came.
Okay, well,
Yeah,
let's,
okay.
let's work our way up to that.
Okay.
What's a high crime and misdemeanor?
It is an abuse of power, an abuse of the power of the presidency or of whatever other high office that is a great danger to the nation. People like Madison, Hamilton defined it in ways that seemed perfectly suited to what we now observe. That is, someone who takes the power entrusted to him or her and uses it for personal purposes to endanger the country, including preventing and obstructing an inquiry into what that person is doing. So that a person who basically uses the office not to advance the country, not to carry out the purposes of the oath, but to advance his or her own wealth, fame, power, influence, and to get reelected, that's a high crime and misdemeanor. And it's exemplified. I mean, there's plenty of history that explains it. There's plenty of history in the colonies and in Parliament. But without going into all of that detail, the very language of the Constitution, treason, bribery, or other high crimes and misdemeanors, sort of the justem generis principle, birds of a feather. What are things like treason and bribery? Those are the things that are high crimes and misdemeanors. It's not literally treason. It's not literally treason to help Russia and to make Russia the source of your guidance when Putin tells you to ask Erdogan what he thinks about what you should do in Syria. Not exactly treason, because Russia isn't an enemy, but it's treason-like. And it is, in fact, bribery to do what he did with respect to Ukraine. And it's indeed extortion, it's a shakedown. So without agreeing on all of the marginal cases of what might be high crimes and misdemeanors, we're now dealing with something that so dramatically and obviously exemplifies the very heart of what a high crime and misdemeanor is, that the lesson that will be taught if this president is not removed by the Senate after being impeached by the House is that nothing counts as a high crime and misdemeanor. That is, we really will not have an effective impeachment power. And that's a scary thing, because the framers of the Constitution realized that waiting until the next election wouldn't always be safe. They talked about how someday the country might raise up a creature. That was a wonderful phrase the framers used. Raise up a creature who is beholden to a foreign government, who is a demagogue, who is in it for himself. And we will need a way to get rid of that person. Now, the way the European countries did it was assassination. And Ben Franklin,
We don't want that. No.
he said that's not the best way.
No.
A coup, a military coup, not the best way. We need a
Not
peaceful,
that either, no.
Right. We need a peaceful way to get rid of a creature who basically uses the office for his own benefit and in a way that endangers our national security. And we are now we are living through that peaceful way. Now, whether there's ever going to be a peaceful way to be rid of this president is anyone's guess. That is, he's unlike Nixon, who knew that his goose was cooked. He didn't have all that much personal decency, but he knew well enough to go out when the going was good. So he could get pardoned, by Ford and all the rest, then go off to San Clemente. This guy is not going to go gentle into that good night.
Okay, well, before we get to his departure,
I'm eager to get there. I have to tell you.
You know, perhaps the most famous definition of high crime and misdemeanor was uttered by Gerald Ford when he was a member of Congress, and there was an unsuccessful attempt to impeach William Douglas on the Supreme Court,
Right.
and Ford said, an impeachable offense is whatever a majority of the House of Representatives thinks is an impeachable offense.
Right.
What do you make of that definition?
Well, spoiler alert, if you get my book, you'll see that I think that's just not right. It's true if you're a complete positivist, and if you say, well, unless a court will prevent you from doing something, it's okay. I mean, it's true that if the House of Representatives wanted to say that Trump's trade policies are so stupid that that's an impeachable offense, and if there were the votes in the Senate to remove him over that, that would be an obvious abuse of the impeachment power. That's not a high crime and misdemeanor. Our system wouldn't work. And yet, there's no court that would reverse it. There's no court that would say, whoops, no, that's not an impeachable offense. I do know there are a couple of scholars who think otherwise and who think that Trump could go to court. Trump has even said himself, I've done nothing wrong. If you try to impeach me, I'll take you to court. Good luck with that. That is, the Supreme Court, and there are good reasons that I explain in the book, the Supreme Court is going to have nothing to do with it. In another Nixon case, a case involving not President Richard Nixon, but Judge Walter Nixon, the Supreme Court held that the question of whether the Senate, which has the sole power to try impeachments, has conducted a genuine trial, is really not a question that a court can decide. So that when, in the case of Walter Nixon, the Senate had a committee make a decision and then just refer it to the full Senate, the court refused to review that. Now, even in that case, the court left open the possibility, and there were two concurring opinions that said, look, there are some things that a court might intervene with, just procedural things, not substantive. For example, if Mitch McConnell, who has promised to actually have a trial, if Mitch McConnell were to say, you know, this is just too tough, I don't want to make my members stand up and be counted, I think we're going to flip a coin. And we're going to flip a coin 12 times, and if all 12 come up heads, he's removed. But if there's a single tail, he stays. I would imagine, though I'm not sure who would have standing to contest that, that would be something a court would say, that is not an exercise of the sole power to try impeachments. But apart from ludicrous examples like that, when the Senate or the House exercise discretion in some way to decide whether this has crossed the line of impeachability, nobody's going to second guess it. Now, that doesn't mean that Gerald Ford was right. I mean, these people take an oath to uphold the Constitution. For many of them, that isn't worth an awful lot. But I think our country would go down the tubes if we started thinking that the Constitution matters only when the Supreme Court is going to slap you down. The court can only take a small number of cases. If we believe at all in the rule of law, we have to believe that the law means something even when nobody's staring over your shoulder and threatening to behead you if you violate it. And it seems to me, therefore, yeah, you can clap.
3 people thought those statements.
You know, so I don't agree with Gerald Ford. On the other hand, I also don't agree with people who think there's some narrow, precise way of defining high crimes and misdemeanors.
And along those lines, one argument that often comes up, or issue that often comes up, is, well, it has to be a criminal offense to be a high crime and misdemeanor. What's your view of that?
That clearly is wrong. For example, bribery was not generally defined in the Federal Criminal Code until 1835 or 1836. Does that mean that bribery, which was an impeachable offense starting 1787, couldn't possibly lead to someone's removal? The definition of a crime in the U.S. Criminal Code is rather narrow and special. There's no reason why something would have to violate a provision of the U.S. Criminal Code to be an abuse of the public trust, to be an abuse of power. There are a lot of things that are crimes which don't hurt the nation in the way that the High Crimes and Misdemeanors Clause contemplates. For example, and this is not necessarily all that hypothetical, suppose it turns out that Donald J. Trump has been committing various federal crimes involving his taxes during the last 2 or 3 years. I don't think those would be impeachable offenses. I don't agree that he shouldn't be subject to indictment for it. That's a different story, whether the OLC memos about never indicting a sitting president should be obeyed or whether that's bad advice. But those aren't impeachable offenses. Conversely, there are a lot of things that aren't crimes that certainly are impeachable offenses. I mean, if the president said, I want now automatically to pardon anybody in prison who is a Trump believer, and those scum who are anti-Trump, I don't want to pardon them. That's a clear abuse of the pardon power, clearly impeachable, not a crime. If the president says to William Barr, I don't want you to ever prosecute a Republican, only Democrats, he's not committing a crime, but nobody doubts that that would be a basis to remove him. So there's just no, there's a little overlap. That is, it helps if something is a demonstrable crime. I mean, in demonstrating that this president committed impeachable offenses, it helps that when he asked Zelensky to help him defeat his principal opponent, Biden, in return for his releasing $391 million, it helps that that's a bribe, and it helps that that is a criminal bribe, and it helps that it's probably extortion. So here we've got the trifecta. I mean, it's an abuse of power, it's a betrayal of trust, it's corrupt, and it's also criminal. I guess it's a quadrifecta.
Talk a little about, it's not exactly related to impeachment, but the OLC memo, the issue of whether a sitting president can be indicted. It's the policy of the Department of Justice. It's not a law, but it's the policy
Right.
that is not appropriate under the Constitution. What's your view of that?
I think it's wrong. I mean, when the president says, I could go out and shoot someone on Fifth Avenue and you couldn't do anything to me, and he's actually, through his lawyers, taken the position that as long as he is president, I mean, he goes, the OLC memo one better. He says that I can't even be investigated for criminal activity as long as I am the sitting president. Well, the absurdity of the position is nicely highlighted by the extremity to which he takes it. I mean, if it really is true that the president has some kind of absolute immunity from criminal process just because he's president, then he literally is above the law. He can make it impossible even to impeach him because he could shoot every member of the House or the Senate that wants to impeach him. I mean, what are you going to do about it? But it seems to me that there's a kernel of wisdom in the memo. That is, it really is true that a normal president who spends his time actually presiding over the country rather than tweeting and watching Fox News and golfing would be stymied in his ability to govern by having to actually sit for a criminal trial. Although that's true when you're impeached as well, but that's provided for specifically in the Constitution. That doesn't mean you shouldn't be able to indict a sitting president and hold the indictment in abeyance, perhaps seal it so that the statute of limitations doesn't run and so that he isn't immune from prosecution when he leaves. But I think that the position of the OLC memo, which was not very well reasoned and was actually an afterthought. They were actually, the original OLC memo in 1973 was written to show that Agnew could be prosecuted, though he was a sitting vice president. And to contrast that, they threw in the idea that, of course, the president couldn't be indicted while in office, but that was never fully developed. And in fact, in a recent district court opinion, there's an elaborate, Judge Marrero, in a wonderful opinion that for those of you who are lawyers, I commend that you read it. It's a very long opinion that even though it's not central to it, this opinion goes out of its way to explain why the OLC memos were so badly reasoned. I think a sitting president should be subject to indictment.
But before we go to questions from the audience, you've already talked about your view of the sort of Ukrainian chapter as an impeachable offense. There are two other likely articles of impeachment. that will at least be considered by the Judiciary Committee, if not approved. One is obstruction of justice, the behavior outlined in the Mueller report with regard to obstructing Mueller's own investigation, among other things. And second, obstruction of Congress, the refusal to produce witnesses and documents. What are your thoughts about those two as actual impeachable offenses?
Well, I'm one of the people who, after the Mueller report was published, thought that we had enough at that point to proceed to impeachment. That is, I believed that, contrary to the obvious lies told about the Mueller report by Bill Barr, that Volume 2 of the Mueller report, even applying the strict standards of the federal criminal laws about obstruction of justice, showed at least 5 instances of witness tampering and other forms of direct obstruction of justice, every bit as serious as those that had been found in Nixon's case by the Judiciary Committee. And I thought that even though Volume 1 did not conclude, though it didn't exonerate, did not conclude that the president had conspired with Russia to become president, that it certainly showed that he had invited the help of a foreign adversary and accepted that help and been benefited by it, and that too was an impeachable offense. In fact, the framers were concerned, even though it's kind of paradoxical, how can you commit an impeachable offense, an abuse of power, when you don't have power yet? No very obvious answer, except that the framers were so clear that someone who commits crimes or gets foreign help in order to become president should not retain that office. So I thought that the groundwork had been laid at that point, as did a number of the people who are now running for president, like Elizabeth Warren. But it was clear that the people weren't there yet. It was clear that the people had gotten past it. They thought, oh, big deal. That's so yesterday. That's 2016. Now, when it turns out that it's not just yesterday, but it's today and tomorrow, it's next year, it's the president twisting arms in order to get dirt on opponents from foreign governments in violation of the election laws in order to be elected in 2020, that's different. And that's why the popular reaction has been so different. And I don't think, even though I don't agree with Gerald Ford that it's all a matter of politics, I don't think politics is irrelevant. That is, I don't think impeachment can really work if you don't get the country behind it. That's why I'm very supportive of Adam Schiff and Nancy Pelosi's determination. And it's reflected not just in the news, not to say that the news isn't important here, it's reflected in the very language of the resolution, H-Res 660 that was voted yesterday. They are clear that they are conducting an inquiry in the Intelligence Committee into the Ukraine events and the surrounding stonewalling of Congress about those events, that is, the defiance of Congress. And there's only discussion in the accompanying report of the Rules Committee. There's only some discussion of the obstruction of justice going back to Mueller. So it's not clear that what's going forward even contemplates the possibility of including in the articles of impeachment anything about the Mueller report. They will, however, include the defiance of Congress in the president's issuance of the statement through Cipollone that nobody should cooperate with this impeachment investigation.
Just the eight-page letter that Pat Cipollone wrote a couple of weeks ago, which is really an extraordinary
It's
document
extraordinary.
people haven't read.
There's nothing in American history comparable to it. Nothing that Nixon did is comparable. I mean, Nixon, yes, he stonewalled on this, he stonewalled on that, and there was an Article 3 that Liz Holtzman helped to write in the Judiciary Committee. There was an Article 3 in which Nixon was going to be impeached, and there was a recommendation of an article of impeachment for obstruction of Congress. But there was no obstruction comparable to this. That is, this sweeping, nobody should cooperate. It's a way of effectively denying the legitimacy of the central function of the Article 1 branch, the checking branch of government. That's astonishing. I mean, just let me say a word about why anyone who compares what's going on now to Richard Nixon is really comparing apples to apple orchards. This is not just an apple. This is an orchard. This, maybe I'm wrong, and Liz Holtzman could correct me if I am. I don't think Nixon was ever directly found to have been involved in the break-in itself, right?
That remains.
It was
that's
only
the
the cover.
historical record,
It was
yes.
only the cover-up. Cover-up is bad, right? But this guy, I mean, the offense itself that he is not only covering up but stonewalling and denying Congress's ability to investigate into, the underlying act of extorting a friendly government, and according to Ambassador Bill Taylor, sitting by while Ukrainians are slaughtered on the battlefield by Russians while he withholds the aid they need, that act is something that he publicly admitted. I mean, just think about it. It's not just the cover-up, it's the underlying act. If this is, I mean, a lot of Republicans in Congress in the Senate are saying, well, it wasn't the best thing, it wasn't the perfect phone call, but we can excuse it, it wasn't impeachable. If this is not impeachable, what could possibly be?
Let's take some questions. All the way in the back there. And speak into the microphone, please.
Yes, I'm wondering what your view is about attempts. That is, attempted obstruction with the intent one does acts tending, or the attempted violation of the Emoluments Clause. Does it have to be successful in order to be impeachable?
Well, actually, the concept of an attempted obstruction is a bit of an oxymoron, because as the obstruction statutes are written, they ask whether there has been an endeavor to interfere with a legitimate inquiry. You don't have to succeed. That is, if you shoot at a witness hoping to scare him away and you just miss, and the witness actually manages to dodge your bullets and testifies, you have committed obstruction of justice, not just attempted obstruction. And in any case, I suppose the relevance of that question now is, does the fact that some ambassadors and some civil servants have had the courage to resist the president's stonewall and to break through the stonewall means that it doesn't matter that he put it up? I think from the point of view of the purposes of the impeachment clause, it makes no difference at all. Even in terms of the criminal law, it would make no difference. But it would be really funny to say that the impeachment power, which is designed to take dangerous presidents out of office rather than wait till the next election, especially when it looks like they are monkeying with the next election. It would be very bizarre for the impeachment power to evaporate and turn into a pumpkin simply because the president was too inept at his various attempts.
This comes up. When I was an assistant U.S. attorney, I tried a couple of obstruction of justice cases, and almost by definition, the crime has to be an attempt, because if it means you got caught, right? I mean, the very act of trying someone for obstruction of justice means the act was unsuccessful because they were interrupted. They did not succeed in stopping the prosecution, did not succeed in whatever they were trying to do. And it applies similarly in the impeachment context. Who else? Yes, sir, over here.
So just thinking about impeachment at a more general scale than the case immediately before us, and how high the bar is set. I'm just wondering, obviously you could read crimes and misdemeanors and just say, look, misdemeanors is already taking you down out of the criminal realm as far as how high the bar should be. And the rhetoric today that it's a coup is, of course, absurd. The rhetoric that it's overturning an election is also absurd, because much as some of us would like to overturn the election, a President Pence would not be an overturning. And I'm wondering whether it's a good time to explicitly lower the bar. That is to say, this is a way to deal with a particular bad actor that's not a huge political move, because the office stays in the power of the party that won the election. And that, it's a time to sort of rethink how high that bar should be.
Yeah, some people, like Ezra Klein and others, have argued that we ought to somehow tune down the temperature of impeachment. We shouldn't think of it as such an extraordinary thing, after all, the president is not deprived of liberty, he's not deprived of property, although say his job is a form of property, he's not imprisoned. We carefully limit, in the Constitution, we limit the consequences to removal unless the Senate also, as it is likely to do, votes to disqualify the person from ever running again. Although a few people have said that the ideal thing here to overcome the argument about nullifying an election would be to remove Trump, but not vote to disqualify him from running in 2020. I think that's a crazy idea.
It'd be really good for ratings.
It'd be very good for
Yeah,
your ratings,
I mean,
right?
yeah.
But the idea of sort of lowering the temperature is not that big a deal, especially since, as you point out, it doesn't really nullify. Not only does the vice president, move to the presidency, but some of the things he's done, like put Gorsuch on the court and Kavanaugh, that doesn't get undone. Although some people write to me and say, why shouldn't all of what he did be undone if he's removed? There are all kinds of reasons. But I think that constitutional culture and history are not so easily manipulated. That is, we can't just by waving a wand say, oh, we're not going to treat it all that seriously. I mean, we've never removed a president by that process. By definition, it's going to be pretty damn serious the first time and even the second. And it seems to me that that's appropriate, because when people voted for Trump, they weren't voting for Pence. I mean, most people were voting because there was something about Trumpism that appealed to them. The guy's the very things that make me gag when I see him are the things that appeal to a lot of people. They didn't vote for the ticket. And so they understandably feel if we get rid of him, the 60 million or so who voted for him will feel that their choice has been nullified. We shouldn't fool ourselves into thinking that they could feel otherwise. Now, it would be helpful if the truth could make people free. It would be helpful if actually seeing what he did would change a lot of people's minds. I'm not holding my breath, but I'm also not exhaling completely, because I think it's possible. It is possible that people would say, this is just too much. We didn't really vote for this. We voted for someone who would wreck things. We voted someone who would talk like we do. We voted for somebody who was not an elitist. We didn't vote for a guy who would shake down a foreign government. We didn't vote for a guy who would put people in cages. We didn't, who knows?
Dean Simon, you had a question. Over at the...
Well, I certainly agree with your view on his having
Could you hold it a little closer?
having committed impeachable offenses. My concern is one that I guess was expressed in today's column by David Brooks in the Times, and that is that, even the Republicans know that he's committed an impeachable offense, but they're not going to distance themselves from their voters, and there's almost no chance that he's going to be convicted in the Senate. And would that, if that is so, would that not undermine the impeachment clause for the future?
Well, it would certainly undermine the impeachment clause, but it would be undermined even more if the House were to delegate its power to the Senate and say, well, because our current guess is that he won't be removed by the Senate, why bother? Why bother to do what our oaths require? Why bother to impeach him? I mean, that would really be a terrible thing. And besides, even if he is not removed in the Senate, his legacy will be stained forever. I mean, I think there's a really good chance that there will be something like 51 votes to convict him. 46 Democrats, maybe not the guy from West Virginia, Manchin, and maybe as many as 5 Republicans led kind of a rump group led by Romney. 51 votes to convict and remove. He wouldn't be removed, takes 2/3, although there's some gimmicky question, 2/3 of those present, it says. Maybe some of them would absent themselves. All kinds of quirky things might happen. But suppose history records that for the 3rd time in American history, an American president was impeached by the House, and this one was impeached for the following abuses of power. That's something. And for the first time in American history, although it wouldn't be the first, I guess Johnson, though not removed, avoided removal by one vote, but there was a majority to remove him. So it would be the second time in American history a majority of the Senate voted to remove. That would leave a legacy. I think it would make it more likely that he would be defeated. People who say, "Oh no," he would crow and say, "I've been exonerated." Well, what else is new? He says that all the time anyway. It doesn't matter.
And who? Well, we have only men asking questions.
Yeah,
Where are the women? There we go, over here.
So knowing Sidney, I think that he would agree with me that one of the big heroes of the day is your daughter and her sense of justice and your willingness and heart to listen to her. And does that happen a lot? And do you think that over history, it's been the daughters who have pushed their elected officials and their fathers or their mothers to?
Great question.
Yeah, I mean, do you have other instances in your own history? And do you think that's happening all the time? As a mother of a 5-year-old, I got very excited about that.
Well, I don't have any empirical evidence on it one way or the other. It would all be anecdotal, but my daughter has given me all kinds of wonderful advice, and I have usually taken it. And I bet that daughters are the saving grace very often in world history. So it's a great question. I think somebody could do a PhD thesis on daughters and their influence.
Okay, over here. Wait for the microphone. No, you're next.
Okay, the real issue here is not impeachment, it's conviction. So what conviction depends upon is how one interprets high crimes and misdemeanors. So a Talmudic scholar might look at that and look at it like an oxymoron, because high crimes is something interpretable as a severe offense, and a misdemeanor is a minor offense. So the two don't go together. So really,
Except a Talmudic scholar would also look at the history and would realize that misdemeanors was not a separate word then. They were thinking of high crimes and misdemeanors as a unit. It was not the idea of high crimes and little crimes. The idea was a high crime and misdemeanor.
well, my interpretation would be that it's not a high crime, it's a crime committed by someone in high authority.
It's much more than that, because the impeachment clause applies to people in low authority as well. That is, William Barr could be impeached. Wouldn't be a bad idea, but he's not.
Okay, the boss here, yes. Wait for the microphone so everybody can hear.
So I'm a little bit concerned about the impeachment in the Senate. First of all, are there going to be dissenting opinions, or is it just either you did it or you didn't do it? And then the second thing is, if he's found to not be impeached, does that validate for the next president and the presidents thereafter that this conduct is really not impeachable?
Or if he's, I mean, that's it. Just if he's impeached but not convicted, does that mean it was all okay?
Well, if he's not impeached, it's much worse than if he's impeached and not convicted. But first, then, when you say he's going to be, I mean, we don't know for sure that he'll be impeached. I would bet almost my life on it, but we don't know. What we don't, you said what matters is whether he's convicted. It matters a lot whether he's impeached. That's the first thing. I just remind you that 2 months ago, if somebody had said he's sure to be impeached, you would have said, what have you been smoking? Right now, we are sure of things that didn't seem at all plausible, let alone sure. So he's now pretty sure to be impeached. Now, if he is impeached and not convicted, well, what history makes of that will depend on a lot of things that we don't know yet.
Including the outcome of the 2020 election.
Yeah.
Right.
Whether he is, for example, roundly repudiated by the American public, partly because he should have been removed but wasn't. And maybe the people who are in the Senate who vote on his side will lose as a result. And then the verdict of history will be very different from what it would be if he's resoundingly reelected and if the people who stood by him are reelected in the Senate.
But
it depends a lot.
Are they sitting as an appellate where there are dissenting opinions, or are they just
No.
finding yes or no,
Yes
like
or no.
like a fact issue? So
Right.
that's all you're going to have. You're not going to have
You're
anything
not gonna have
guiding you for
written
the future.
opinions,
No
no.
written opinion.
There will be a written report from the House of Representatives accompanying the articles of impeachment, and then the impeachment managers who are appointed by the House, I'm not sure who they will be, but Lindsey Graham was the main impeachment manager. He was the head of the managers against Clinton.
They're usually members of the Judiciary Committee,
Yeah.
but they don't have to be.
They don't have to be. I bet Schiff is more likely to be among the impeachment managers than not. But there will be no opinions. That is, the Senate will vote. They will vote on one article after another.
Okay, let's take two more questions. This gentleman over here.
Larry, speak for a moment to a point that Liz talks about a lot, Liz Holtzman, about the importance of public hearings, because we now are into that next phase. Cannot that make a critical difference?
Yeah, well, I think it's extremely important. I mean, as of now, it looks like public hearings may begin on November 12th. If you read the procedures that were established, the closed depositions continue briefly in the Intelligence Committee, and there will continually be complaints from the Republicans who are present at those hearings. They get to ask questions, but they will pretend that, unlike a grand jury and unlike what prosecutors do, that everything should be wide open. But that'll be over, and then when, on November 12th, the Schiff Intelligence Committee begins hearing publicly from people like Admiral,
Colonel Vindman?
Colonel Vindman and Ambassador Taylor and others, and it's going to be very dramatic. They will hear what now they've only heard about, and they will see, and they will be able to see the credibility. And this guy will come in
his badass uniform.
Badass uniform with his Purple Heart. It's going to be very dramatic. And that is what changed a lot of public opinion in the Nixon case. And I think here, it's going to be much more dramatic in many ways, because in the Nixon case, we were all talking about, what did he know and when did he know it when it came to the cover-up. This will be, when did he pull the trigger against an ally of ours? He didn't shoot someone on Fifth Avenue, but he shot a lot of Ukrainians on the battlefield.
Last question, sir, over there. And then our host.
What do you think of proposals to expand the number of justices on the Supreme Court, including the somewhat indirect way if it would pass constitutional muster so that the additional ones would not necessarily be partisan?
It's a long story. I don't buy the idea that since the other guys have done such terrible stuff like holding off on Merrick Garland until they could seat Gorsuch, that now we have to play hardball and pack the court. I think that would come back to haunt us, and I'm not for that. People like Pete Buttigieg have these more elaborate schemes of 15 justices, 5 Republican, 5 Democrat. How the hell can you? It's just so complicated. I think Buttigieg is very smart, but on this one, I think he's gone off the deep end, honestly. And Elizabeth Warren, too. I mean, they more or less, to win the primary, have to say they're in favor of doing something to the court. I'm in favor of term limits, for example. The more complicated plan that would make almost every appellate federal judge a Supreme Court justice, but then they would rotate, and some of them would sit for a while and then they would leave. Probably unconstitutional, because the Constitution talks about holding this position for life and not just a federal judicial position. But I think that all of those gimmicky things are likely to be much more complicated than they're worth, and to undermine whatever is worth preserving of the independent judiciary. I admit there's a strong case to be made to the contrary, because those of us who care about what the court does to abortion, to issues of equality, to gerrymandering, to everything else, realize that we are stuck for decades with a court that is extremely far right, and that's very sad.
Can we have a last word from our host? Did you want to say? Just wait for the microphone.
I just want to say that it's been one of the most, it's been a fabulous lecture.
Thank you.
Well done.
Thank
you all.
Thank you all very much.
I have one more sentence to add. And we've been very privileged, and Liz Holtzman wrote a fabulous book too. So a little shorter, but very interesting. But there is a copy. Larry Tribe was kind enough to inscribe his books, and there is a copy for everyone. So I hope you will stop and pick up your book. And I thank, really, I thank you both for doing such a great job. And impeach now.